Good day and welcome back to another episode of Stratagem LP's Legal Podcast, where we dive deep into some of the most vital legal cases and key legal issues impacting Nigerian legal jurisprudence. In this episode, we'll be reviewing the Supreme Court case of CBN versus Interstella Communications Ors, a case that focuses on a crucial legal question about whether the consent of the Attorney General of the Federation is a condition precedent before funds held by a public officer can be attached through the instrumentality of Garnishee Proceedings. We will break down the key points of the case, explore its background, and discuss the implications of the court's decision. Let's jump right in. First, let's discuss the legal provision that forms the basis of the appellant's argument, Section 84(1) of the Sheriffs and Civil Process Act. This section stipulates that before funds in custodial leges, that is, in a public officer's custody, can be garnished, the Attorney General of the Federation's consent must be first obtained. Now, in this case, the appellant claims that the specific provision was not followed. Specifically, the AGF's consent was never sought before the order NISA was made in the case. So the central legal issue here is whether this legal step, christened condition precedent, was mandatory and whether the failure to obtain consent could affect the legitimacy of the Garnishee Proceedings and the consequent order made by the court. Next, let's look at the background of these Garnishee Proceedings. The proceedings stem from suit number FHC UMCS 95-2004. In this case, an interministerial committee, which included the AGF, was set up to help negotiate the settlement of debts owed by NITEL, i.e., the defunct National Telecommunications Limited, to the first and second respondents. This committee was essentially working to resolve a significant financial issue, debt owed by NITEL. It involved some delicate negotiations between public bodies and private entities. As part of the negotiations, the federal government, through the committee, proposed a settlement plan involving innovation of 24.66 billion naira to the first and second respondents. After the court delivered its judgment in the above sum, the parties further agreed and filed terms of settlement for the sum of 12 billion naira as full and final payment. This settlement aims to resolve the matter in the national interest. Now, you may wonder why this specific amount and negotiation were so important. Well, this debt was not just a simple financial issue. It had broader implications for public interest and national policy. Hence, the involvement of key government functionaries and figures like the AGF. A presidential instruction to the AGF adds another layer to this case. The instruction asks the AGF to handle matters related to the Judgement Debt Verification Committee, which was working with the Interministerial Committee's recommendations. This shows that the AGF wasn't just a passive participant in these negotiations. The AGF was actively involved in making decisions to address the matter with the aim of serving national interest. So, the big question becomes, was the AGF's consent truly necessary before initiating Garnishee proceedings, especially when the AGF was already deeply involved in negotiations and settlement? This brings us to the main issue on which the case focuses. Was the Attorney General's consent required as a condition precedent before the Garnishee proceedings could be initiated against a government agency like the CBN, even though the AGF had been working on this issue at the national level and was involved in various settlement efforts? And is the Central Bank of Nigeria considered a public officer so as to bring it within the purview of the said Section 84 of the Sheriffs and Civil Process Act? In her lead judgment, Justice Ogunbiyi provided clarity on this matter. He held as follows, and I quote, "In other words, and as rightly argued by the first and second respondents' counsel, the appellant is not a public officer in the context of Section 84 of the Sheriffs and Civil Process Act when regard is had to the history of this appeal. It is apparent on the facts of this case that the CBN acts as a banker to the federal government with respect to government funds in its custody. Section 2E of the CBN Act states that the CBN shall act as a banker and provide economic and financial advice to the federal government. Section 36 of the CBN Act also provides the bank shall receive and disburse federal government monies and keep accounts thereof. The appellant does not stand as a public officer in this situation. Therefore, it follows that the need to seek the consent of the Attorney General of the Federation does not arise. Justice Ogunbiyi referred to the case of CBN versus Ekong, wherein it was held that the Central Bank of Nigeria was established not for profit-making purposes, but for control and administration of the federal government's monetary and banking policies. This precedent helped affirm the view that the CBN is not treated as a public officer in this context. Ultimately, the judgment concluded that, in this case, the CBN is not a public officer under Section 84, subsection 1 of the Sheriffs and Civil Process Act, and as such, obtaining the Attorney General's consent is unnecessary before initiating Garnishee Proceedings. This case was referred to in the most recent Supreme Court case of CBN versus Uchife, 2025, which analyzed this vexed issue further, especially the minority judgment of Ogunwumiju GSC, which held that the said Section 84(1) is a vestige of military rule, which no longer has a place in the current Nigerian legal jurisprudence. Section 287 of the 1999 Constitution, having deleted subsection 4 equivalent of Section 251, subsection 4 of the 1979 Constitution. She concluded by holding that the said Section 84(1) of the Sheriff and Civil Process Act is inconsistent with Section 287 of the 1999 Constitution, and shall, to the extent of that inconsistency, be null and void. So there you have it, CBN versus Interstella Communications and others. It's not just about a technical issue of consent. It's also about the broader question of how government entities and public officers manage financial obligations and national interests. Thank you for listening to this episode of Stratagem LP's Legal Podcast. I remain your principal host, E.P. Ojuma Esquire. My special thanks to my review assistant, Ms. Oyin Damola Daramola. Join us next time as we continue to explore the legal issues that shape our society. Until then, stay informed, stay empowered, and keep learning. Thank you.